Well, thank you so much. Hi, everyone. It's very nice to be with you here tonight. My name is Jen Grobe. If you have any questions during the presentation, please feel free to put them in the chat. I'll try to take a look as I'm going so I can kind of integrate them as we're talking about each subject, but I will try to reserve about 15 minutes at the end so we can have some more discussion and answer any questions you may have. So today we're talking about educational services for children with disabilities, and we're going to focus on children who have pain disorders or chronic migraines and who may need services and to support them in that area. So one of the most important things generally to understand about educational planning for students with disabilities is that special education is an array of services. It is not a placement. So when a student is getting special education, they are getting services and supports for their disability. And these supports and services are individualized to meet their particular needs. So the general purpose of special education is to ensure that all children with disabilities have available to them a free, appropriate public education. And that's a key word you're going to hear there, free, appropriate public education. Shorthand is FAPE. That emphasizes special education and related services designed to meet the students' unique needs and prepare them for further education, employment, and independent living. So keyword there, the entitlement to free, which means parents don't pay, appropriate, which is a complicated legal term that has been sussed out in the courts, public education. So students with disabilities may be entitled to one of two different types of plans that schools offer. A student might be entitled to an individualized education plan, or they might be entitled to a 504 plan. And this is particularly relevant for the children and students we're talking about today, because often I find that school districts don't necessarily understand the additional services and supports a student with chronic pain might require other than accommodations through a 504 plan. So really today we're going to talk about the difference between that IEP and 504 plan, kind of the process of getting one of those in place, and if there's a dispute with your school district about the services that are being provided, how you can appropriately address those. So the first thing to keep in mind are everything we're talking about is governed by federal statutes or state statute. I have Pennsylvania in here because that's where I'm from, but mostly everything is governed by these federal statutes, the Individuals with Disabilities Education Act, or Section 504 of the Rehabilitation Act of 1973. And then there will also be state authority that is governing in your state. But the state services can never be less than what is required under federal law, but there may be additional requirements on top of what the federal laws require. There are also several other federal statutes that govern the rights to a student in public education. Just want to list them here. One that may be relevant to what we're talking about is the Americans with Disabilities Act, which prohibits discrimination against persons with disabilities in state and local government services or programs, including in public schools. And then there's various other civil rights statutes that may come into play, but really we're focusing on our kids with chronic pain, how we're meeting their needs, and that is going to be through either an IEP or a 504 plan. So to kind of get a general understanding, what is a 504 plan? What is IDEA? How does a student qualify? What's going on here? I think that this is a great visual to kind of understand what we're talking about here. So if we're looking at all children as this big circle, and then students of a protected class are a subsection of all children. Then that would be students who are protected based on disability, gender, sexual orientation, race, national origin. basically any of those civil rights discrimination statutes. Now, students who are Section 504 eligible are students with a disability, and these are children with a physical or mental impairment that substantially limits a major life function and who requires services to access curriculum. And we're going to get more into that, but it's just something to generally understand. And students who are IDEA eligible, they not only have those physical or mental impairments that are limiting to their ability to access curriculum, they also need special education or specially designed instruction to meet their unique needs. That's beyond what's in general curriculum. It's beyond access. It's getting something more. So if a student qualifies for IDEA, they're going to qualify for Section 504 automatically. If a student qualifies for Section 504, they don't necessarily qualify under IDEA. Now, what is the difference here? So the Individuals with Disabilities Education Act is an entitlement law, which means if a student qualifies, they are entitled to a certain quality of service. And the IDEA spells out a huge range of requirements for students who are eligible. It's about determining eligibility, appropriately evaluating. It's about what needs to be in that individualized education plan and what rights does a parent or educational decision maker have to enforce that student's rights under IDEA. So a student qualifying for IDEA is a narrower eligibility criteria than qualifying under 504. Parental participation is guaranteed for students with who qualify under IDEA. And for the purposes of IDEA, a student who's entitled to FAPE, free appropriate public education, they are entitled to make meaningful progress, essentially, to make meaningful progress commensurate with their abilities. Now, when we're talking about students who qualify under Section 504, which also includes students who qualify under IDEA, Section 504 is a civil rights law, which means it's an anti-discrimination statute. So free appropriate public education in terms of Section 504 is about having equal access to the general education curriculum and environment. Generally, when we're looking at a 504 plan, we're not looking at specially designed instruction to provide anything, like I said, above and beyond what's in the general education curriculum. We're looking at accommodations so that students can access the general education environment. Section 504 also has less explicit standards for what needs to be in that 504 plan and for the processes that are required for a school district if there's disagreement about a 504 plan, for the creation of a 504 plan. It's a little bit more nebulous, but often there's state guidance that is going to guide the school district and what they have to do for a Section 504 plan. So looking at IEP versus 504 plan. An IEP provides individualized special education and related services to meet the unique needs of the child at no cost to the parent. A 504 plan provides services and changes to the learning environment to facilitate a child with a disability's access to education at no cost to the parent. So, and likewise, I said there is a FAPE entitlement in both an IEP and a 504 plan. FAPE, for the purpose of IEP, means that the IEP has to be reasonably calculated to afford meaningful educational progress in all domains commensurate with that student's abilities. And those are very specific words that have come out of the Supreme Court. An IEP must be reasonably calculated to afford meaningful educational progress commensurate with the student's abilities. A 504 plan, on the other hand, is talking about access. So the question is, does the services and related supports, are they designed to meet the student's individual needs as adequately as the needs of non-disabled students? So we're actually not really talking about a guarantee of meaningful educational progress here. We're just saying, are they accessing it the same as their peers can access it? So with respect to eligibility, and the student will be eligible for an IEP if a determination is made that their disability impacts their educational performance and or ability to learn and benefit from the general education curriculum, leading to the need for specialized instruction. And students who qualify under a 504 plan are students who have physical or mental impairment that substantially limits a major life activity and that disability interferes with their ability to learn in a general education classroom. So it has to be both. Just because a student has a physical or mental impairment doesn't necessarily mean it's impacting them in the classroom. If it's not impacting them in the classroom, they may not qualify for a 504 plan. And something to keep in mind about qualifying under Section 504 as having a disability that physical or mental impairment that substantially limits a major life activity. A lot of things will qualify because major life activities include learning, walking, reading, visual activity, listening, hearing, really there's so much that qualifies as a major life activity. If a student has an identified disability, it's likely that they have an impairment that's substantially limiting a major life activity. Then the question is, does that limitation impact them in the classroom and accessing their education? So school districts have what's called a child find obligation. And that means that districts have an obligation to locate, identify, and evaluate all children who are reasonably suspected of having a disability and require special education. So it's not the parent's responsibility to request an evaluation or special education services, although they can. Parents are welcome to make that request for an evaluation or for the development of a 504 plan or IEP. But it's the school district's responsibility to identify students who may need special education supports, who are not able to access the classroom, who are not able to keep up with the curriculum, who are falling behind, and might be due to disability. So a student is found eligible, or eligibility is determined based on a comprehensive educational evaluation. And whether the student qualifies for an IEP or a 504, whichever one we're talking about, the first step should be a comprehensive evaluation to determine which one the student qualifies for. So even if the student isn't going to qualify for that IEP, they likely still need a full evaluation. And we'll talk about the contents of a comprehensive evaluation. And the purposes of an educational evaluation are beyond just identifying if a child has a disability as defined by the IDEA. The purpose is also to gather relevant information to determine the child's individual specific educational needs and to guide the team in making appropriate educational programming decisions for the child. And that is, to me, more critical than identifying if a child has a disability or if they meet the criteria of a disability under IDEA. What really matters is not what we're categorizing them under. It's about what are their educational needs and how are we going to appropriately meet them. And that is the kind of core purpose of the evaluation. So under IDEA, the initial evaluation of a child is required before any special education and related services can be provided to that child. In Pennsylvania, this is also the case for 504 plans. A student must be evaluated first before any services can be provided. The evaluation must be sufficiently comprehensive to identify all of the child's special education and related service needs, whether or not they're commonly linked to the disability category in which the child has been classified. So for example, when we're talking about students with chronic pain, you know, chronic pain isn't necessarily linked with social, emotional issues or behavioral issues, but the student perhaps will have some social and emotional issues that need to be supported as well, that may be related to the disability, but are a separate area of support that are needed. So, the student doesn't need to be diagnosed with a mental health disability, with anxiety or depression to get supports in that area if it's an area of need. When a district, so the process of evaluating would be either the parent requests it or the school district initiates it. Either way, when the school district agrees to evaluate, and we'll talk about what happens if the school district doesn't agree. When the school district agrees, they should issue a prior written notice, PWN, requesting permission to evaluate the student. And the parent must sign the permission to evaluate the PWN before the evaluation can take place. Once that the parent or educational decision maker returns their consent for the evaluation, the district must complete that evaluation within 60 calendar days from the receipt of that. PTE is permission to evaluate, and usually it's part of prior written notice, PWN. As you all may be aware now, special education is an alphabet soup of acronyms, so I may slip in some acronyms that you aren't familiar with, so please let me know if I do that. So if a district refuses to evaluate, sometimes what I'll see is a district parent requests an evaluation, the district says no, they don't need an evaluation, and then it kind of ends there. Parents don't know what to do. What I recommend is if the district is refusing to evaluate, you say, I want you to issue a prior written notice, a PWN, which is also another form as part of this that will be issued is the notice of recommended educational placement. That is a form of prior written notice. So you want the school district to issue a notice of recommended educational placement denying your request, so that there's documentation that they consider the evaluation and they denied that request for an evaluation. The reason you want that is because it will trigger your ability to seek due process and to file with the state to challenge that decision because they've issued that formal notice that they're denying your request. So a comprehensive evaluation, and again, these are all going to be individualized decisions based on the child's individual needs, but generally the areas of assessment you'll see are general cognitive assessments, you'll see tests of academic achievement, and then you'll see social, emotional, behavioral rating scales. Those are the three core that are probably part of every educational evaluation you see. At the very least, those are three things that should be included. But in addition to that, you want to see a comprehensive educational evaluation include a review of their educational history or medical history. Definitely want parental input. That's mandatory as part of the evaluation. There should be an observation in the relevant environment to which there's suspicion of special education needs that aren't being met. And you want a comprehensive review of records. So somebody that's gone through all their educational records, a school psychologist who has conducted the evaluation and reviewed all of the needs. Other aspects of an evaluation that may be included are assessing the student's speech and language skills, looking at their motor abilities, visual motor, gross motor, fine motor skills that may require occupational therapy, vision and hearing assessment that may go above and beyond just the general vision and hearing screening that all students receive. That could include also for hearing assessment for auditory processing issues or auditory processing disorder. And that may, if we're seeing students with listening comprehension issues, then there may be an auditory processing issue there that should be assessed by an audiologist. We're also looking a psychiatric assessment may be necessary as part of a comprehensive educational evaluation, and also assessment of the student's executive functioning and their attention. And learning and memory are other areas of assessment you may want to consider. So some of the common refusals and rebuttals I've seen or heard, and this was from the Alliance for Children's Rights, which I think this is kind of spot on, is schools might say, well, we should try other interventions first before we evaluate and see if they need a plan. You know, we don't think they'll be eligible, so we don't think it's not necessary to evaluate. You know, that the reason that there are educational problems right now is due to attendance, so there's no special education needs, or that, you know, the student's too new, so we don't need to assess because we need to get to them to know them better. None of those are valid reasons to not assess a student. You cannot prolong an evaluation when you have reason to believe a student has a disability impacting their education. So you can try interventions first. That's not a valid reason. Often you'll see this with students with reading disabilities, where you know, you'll see schools that have multi-tiered systems of support. I think that's the MTSS. I think that's the acronym, or I know that's the acronym. I think that's what it stands for. That they'll say, well, let's go through the MTSS process and see first if it remediates there before we evaluate. That's not a reason to prolong evaluation. Making an assumption the student isn't eligible isn't a reason to deny evaluation. Eligibility is determined based on evaluation, not based on the preconception of one person in the school district. Attendance problems, that could be stemming from disability. So it's important to do the evaluation to see what's driving the attendance problems. Because if we're looking at chronic pain that's not being accommodated, if we're looking at anxiety, if we're looking at sensory issues, you want to, you know, that are contributing to those attendance problems, that can all be figured out through an evaluation. So ultimately, the response to those excuses is, it doesn't matter, you have to conduct an evaluation, and if you're denying this request, put it in a NORAT, put it in a prior written notice, so that you can challenge it, basically. And I would say kind of 9 times out of 10, if you have the wherewithal to be saying put it in a NORAT, they're probably just going to go ahead and do the evaluation because you probably know what you're talking about. Another thing to keep in mind is if a school district conducts an evaluation and you don't think it's appropriate, it's thorough enough to really assess all areas of need. For example, maybe it's not really reviewing the history of the student, it's not including parental input, there's no observation of the student, there is no social emotional behavioral assessment, then you may be entitled to an independent educational evaluation. And that is something a parent can request at public expense. An independent educational evaluation is exactly what it sounds like. It's an educational evaluation conducted by an independent party outside of the school district to kind of double check and determine whether the student has special education needs that are not being met, and produce recommendations for that. So if a parent or educational decision maker does not feel that the school's educational evaluation is thorough, they can request that independent evaluation. And in response, the school district can only do one of 2 things. They have to either agree to that independent educational evaluation and fund it, and the parent gets to pick the evaluator, or the school district has to file for a hearing and defend their own evaluation as being appropriate. And if you contribute a private evaluation or an independent educational evaluation to the team for consideration, they must consider the evaluation, but they don't necessarily have to adopt the results or the recommendations, but there must be consideration, which is, you know, that's kind of nebulous because they could say, well, we considered it, but we don't think it's necessary. But the question is that reasonable to deny what the outside evaluation is saying? And the outside evaluation, other than being an independent educational evaluation, maybe that's a psychological assessment that has taken place. Maybe that's an assessment that was done by the student's medical team, and those results and the evaluation results are relevant for the educational team to consider. So for students that qualify for under the Individuals with Disability Education Act, meaning they require specially designed instruction above and beyond what's part of the general education curriculum, there are 13 different disability classifications they may fall under. But something to keep in mind is that the classification does not drive the services, it's the individual needs. So let's say if a student qualifies under a specific learning disability, that's what they're qualifying under, but they also need social and emotional support. They need a functional behavior assessment and a positive behavioral support plan. Those can all be included in the student's IEP, even if those needs don't necessarily fall generally under specific learning disability or what you would expect for specific learning disability. Sometimes what I'll see, and I'm not sure if this is happening in other states too, some schools will say this is a speech only IEP, so it can only have speech services, but that's not true. So if a school tries to tell you that, you know, they have a speech only IEP and that's all the only services they qualify for, that's inaccurate. All of the educational decisions need to be made on an individual basis, and there cannot be a general global rule like that students with speech or language impairment and that's it, can't get anything else. No, that's not going to cut it. When we're talking about our kids with chronic pain, with migraines, likely they're going to fall under this category of other health impairment. And other health impairment means having limited strength, vitality, or alertness, including a heightened alertness to environmental stimuli that results in limited alertness with respect to the educational environment. That one is due to chronic or acute health problems, and IDEA does specifically delineate a few health problems that may give rise to other health impairment. Chronic pain and or pain disorder and migraines isn't included in this list, but this list is not, there can be more disabilities that qualify other than what's in this list. Most often, you know, schools will associate other health impairment with ADHD or ADD, but the other health impairment is really anything that has to do with, you know, students having limited strength or alertness to access their educational environment. And again, that also has to adversely affect their educational performance. It's not enough just to have a diagnosis of chronic pain. It has to impact educational performance. So when we're talking, so, you know, if we've talked about evaluation, we're at a point where students been evaluated, a determination has been reached whether student qualifies for an IEP or a 504 plan. So who participates in developing those plans? For developing an IEP, because the IDEA has a lot more specific detail on what needs to be included, or the procedural requirements of meeting that student's educational needs, it specifically delineates that for a student with an IEP, there must be at least an annual meeting that includes the parent or educational decision maker, a general education teacher, a special education teacher, and a district representative who has authority over special education services. School psychologist isn't necessarily mandatory on the team. I don't know why I put that in there, sorry. But if there's an evaluation that's done, there should be a school psychologist that's on the team who can contribute and participate in at least that initial IEP meeting. But something to keep in mind about that district representative with authority over special education services. What I mean by that is it has to be a district representative who has the ability to allocate funds, who can say, yes, this student requires special transportation, they require an aide, they require assistive technology, and they have the power to allocate funds to do that. It's not somebody who says, well, I have to go check to see if they'll permit it and they'll pay for it. Then that is not somebody who qualifies as a district representative with authority over special education services, and that it will be an inappropriate IEP meeting. For developing a 504 plan, there really are no specific requirements about who contributes to the creation of the plan. There might be on a state level, but not on a federal level. The schools could even, create a 504 plan without parent input and begin implementing it, basically. The parent doesn't necessarily have the right to have input into that 504 plan. So the content of these plans. Now, an IEP, kind of on its face, an IEP will use, at least in Pennsylvania, we're looking at a document that is usually around 50 pages. So really comprehensive, thick document that has all of this stuff in there. It has a description of the student's present levels of academic and functional performance. It lists some educational goals for the student that are going to be monitored for progress throughout the year and reported to the parent. It has a big list of the specially designed instruction, modifications, and related services that the student needs, in addition to supplementary aids and services. And it will have, for students over the age of 14, it will have transition planning in there, which means planning for the students' post-secondary education, employment, or independent living, if that's an area of need. Generally, we're going to see a really detailed document here. For 504 plan, sometimes these are 1 to 2 pages, and there's really no standard or regulation of what needs to be in there. Often, what you're going to see in a 504 plan are accommodations so the student can access the classroom. We're not going to see specific modifications to the instruction or specially designed instruction that will provide above and beyond just access to the environment. So, I just listed a few different services. So to kind of clarify what these different services that a special education plan can include, specially designed instruction, SDI, that is the core kind of entitlement for a student who qualifies under IDEA. And that is a specially designed instruction is modifications of the content, methodology, or delivery of instruction. For an accommodation is removing a barrier that to provide equal access to learning. So you're not changing anything about the delivery of the instruction, about what the student's learning. You're changing how that instruction is being delivered. Supplementary aids and services are looking at the services or supports the student needs to be able to be with their general education peers as to the greatest extent possible. And that might be having a one-to-one support, that might be having assistive technology, that might be some support in extracurriculars. It could be just anything that's really focusing on accessing general education, being as included as possible. And related services are the additional services a child needs to receive in order to benefit from special education. And we'll go through some examples of that. So some examples of accommodations that you might see, especially for the kids with chronic pain. The student might get an audio recording of text that they can listen to instead of having to read it. They might get spoken directions, provision of notes or outlines ahead of the class, reduced text or larger text, extended time to complete things, chunking, which is when the teacher kind of helps delineate different portions of the assignment. So in a step-by-step plan, so that it's not so overwhelming for the student. An accommodation could be preferential seating. It could be having a sensory or movement break throughout the day, or the ability to take a break if it's needed. Or it can be having assistive technology like a reader, a speech to text, text to speech that will enable them to participate in their general education classroom. And modifications or the specially designed instruction, we're talking about a student receiving direct instruction beyond the general education instruction. So that might be direct instruction in decoding skills and reading skills, extra direct instruction in math or writing. It could be in social skills. It could be in coping skills. it could be in really anything that we're talking about that's just above and beyond the general curriculum. Another modification could be if the student needs to learn in a small group environment, or if they need one-on-one instruction in order to make educational progress. It could be needing to have material pre-taught to them, having it retaught to them after the fact, or it can be instruction in the home, which is something that will often come up for our kids that we're talking about. But you see the difference there is the delivery of that instruction. They're not in that general education environment. They are getting their instruction in a different way. And if this is happening, if the student is getting their instruction in a different way, then this should be part of a IEP, not part of a 504 plan. And sometimes with these students with medical disabilities, there'll be assumptions that it should just be under a 504 plan. But if we're looking at this sort of instruction, modification to the instruction, it should be part of an IEP with a description of their present levels, with goals, and with progress monitoring. I'm not going to read through this. You'll get a copy of these slides, but there's a difference between specially designed instruction and some assumptions that people will make about specially designed instruction. And kind of the core thing that I'm going to repeat that I said in the beginning is that specially designed instruction is not a placement. It is not a special education room. It is a specific service for that student that can be delivered in a separate environment, or it can be delivered in the general education environment. It depends on the individual needs of the student. So the related services are the additional services a student may need to access to benefit from their special education services. And related services might include psychological services or counseling. It could include rehabilitation, social work, school health services or nurse services, speech and language services. Specialized transportation is a big one. If the student can't be on a large bus or large, loud transportation, they might need private one-to-one transportation in the morning and after school so that they're available to learn at the start of the day. Because if a student with chronic pain or chronic migraines is taking a big loud bus to school and it's triggering migraines, it's definitely going to impact their ability to access their education when they arrive at school. Related services could include audiology, like we discussed before. If there's an auditory processing disorder, it can involve interpreting services, occupational therapy, orientation and mobility services, parent training, counseling and training, or physical therapy. Could also, something to keep in mind with that kind of orientation and mobility services is that may be helpful for our students with chronic migraines or chronic pain. And that may not be something that that a school district will naturally think about when we're talking about a student's needs, because that might be more associated with students with physical disabilities, students who have visual impairment, students who are deaf. But a student with chronic pain or migraines may also need supports and services to better learn how to navigate in their community, to how to basically get around and in accommodating their disability. Something else to keep in mind is the requirement to place a student in the least restrictive environment. So a student must be placed in the least restrictive environment so they're educated with non-disabled peers to the maximum amount possible, and are provided supplementary aids and services to enable them to be with their non-disabled peers to the maximum extent possible. So if we're looking at kind of the continuum of placements from least restrictive to most restrictive, kind of the least restrictive is going to be all the time in a regular education class. Then getting more restrictive, we're talking about maybe having some time pulled out to be in a special education class for a little bit, or special education classroom. It may be a specialized school that is entirely for students with specific disability who needs that sort of placement in order to make progress. Home instruction would be more restrictive than that. And then the most restrictive would be instruction in hospitals and institutions. So sometimes this least restrictive environment will come in play for families who are requesting instruction in the home to accommodate the student's chronic pain or migraines because the student isn't able to go to school. And the school might say, well, that's not their least restrictive environment, so we can't provide it there. But kind of the response there is, well, it needs to be the least restrictive environment that will enable the student to make educational progress. So and we don't have to shove them in the regular education class and have it fail and move our way down to the more restrictive environments if we have enough reason to believe that the student will not be able to succeed in a less restrictive environment than home instruction. And something that I've touched on a little bit, but just want to remind us of, education is more than academics. Education is not just academic progress, not just reading, writing, and math. Education is looking at the holistic development of the child. It's talking about their social development, their emotional development, behavioral development, because all of those are crucial to their ability to transition into adulthood and be a successful adult with the most the greatest extent of independence possible. And a student can earn good grades and still have a disability that requires accommodation or specialized services. If a student is only having behaviors or concerns in one environment, that doesn't mean that that there's not a general disability that needs to be addressed. It's about figuring out why it's happening in that environment. And a student can be gifted and still have a disability. And so that means that a student could have really high cognitive scores, really kind of a high cognitive assessment or achievement, high academic achievement, but still have a disability that's impairing their ability to access their education, or that they need additional instruction on top of the general educational curriculum in order to make meaningful educational progress. But parental involvement is a critical aspect of the IDEA. It was fundamental in its creation to enable parents, educational decision makers, to have a say in their child's education. So when students qualify for an IEP, the school is required to include the parent in designing the IEP. They must provide prior written notice, PWN, before they make any changes to the child's IEP. They can't just unilaterally make changes to the services without parent consent. The parent must consent to any evaluation or change in services, and the parent has the right to have their child stay put in an educational environment if a dispute arises between the school district and the family about what the correct educational program or placement is. So what that means is, let's say, we have an IEP in place, the school district proposes a change in the IEP, or they say, let's take them down to a 504 plan. And as a parent, you're disagreeing with that. You don't think that's appropriate. The school district will issue a NOREP, Notice of Recommended Educational Placement, and that will say, this is what we're recommending to change. And as a parent, you have to check off the box that says, I do not approve this action, and file for due process within 10 days and to preserve the last agreed upon IEP. So the changes that the school district is proposing won't go in effect until the dispute's resolved. That's a right you have as a parent to preserve the child's IEP if you're disagreeing to changes. For a 504 plan, there are fewer procedural safeguards to protect the parent and child. There are notice requirements, but parents don't have to be included in meetings, but they do have to consent to an evaluation. In Pennsylvania, students who qualify for a 504 plan actually have the same procedural due process rights as students who qualify for an IEP. So that is something you might want to check with your state if you have the same procedural rights as a child with an IEP. But generally, I would recommend, if you are getting a special education plan for your child to try to make it an IEP, to do your best to make it an IEP, because there's more protections, there's more that's going to be included in there. They're going to have the goals, it's going to outline their present levels, and it provides you with the opportunity to have more input. So I say always try to advocate for that IEP if the child has a disability and the school is trying to say, well, it can be met through a 504 plan. When we're talking about reevaluations and reviewing the IEP, there has to be an IEP meeting at least once per year, and the student has to be reevaluated every 3 years. For students with a 504 plan, there's not a requirement for an annual meeting, and reevaluation is done as needed. For dispute resolution, and these are Pennsylvania oriented, I'm sorry, but it's probably similar or the same in your states. For students with an IEP, you can seek IEP facilitation or an IEP kind of mediator with the state who will come in and help facilitate the IEP meeting. You can request mediation with a mediator, or you can request a due process hearing, which is filing a complaint claiming that your student is not receiving a free appropriate public education. That is Pennsylvania specific, so I'm not going to go into that, and we're running to the end. So let's look. We have a few different questions here. Does anyone, I'm going to look through these, but does anyone want to chime in and ask any questions?
Jen, can I just ask, this is Casey, can I just ask a quick question though? Sure. Just because I know that I just went through this, and this was like the biggest thing that I learned was my son had a 504 going all the way through up until high school. And then the biggest thing that I learned was to switch him over to an IEP for when he went to college. Because going to college, they will only look at an IEP. They actually won't look at a 504 when you go to college.
That shouldn't be how it is. The Disability Services Department of any college or university needs to make a determination of qualification for a 504 plan in college, because students won't have an IEP in college. They'll have a 504 if they qualify. It shouldn't be limited to students with IEPs that they'll consider. They may require an evaluation report or a recent evaluation report to look at whether the student qualifies for services, but it shouldn't just be, blanket. If your student doesn't have an IEP, they don't qualify for 504 in the college.
And that they did. And so that I learned as well. Thank God, because if not, I would have had to have paid to get him evaluated. So he got evaluated his senior year just because of how it fell for him. So I did not have to pay to get him reevaluated. And my son is visually impaired. So his is like a documented disability for his sake. But I did just so I didn't know if that was kind of how it went for everybody. So I just was going to touch base on that for other people. I didn't know if that was kind of a thing, or if you had run into that for others.
It's a really great idea to request an evaluation in senior year to prepare for that transition. That's a really great idea. And if you can get the school district to agree to it, I would definitely recommend that.
And then I would just like to say, and piggyback with that with Ms. Casey, it's important too that when you do go to the colleges, like we just started doing it because my son is a rising senior. So we just started going to the colleges for visit. We made it a point to also schedule, if at all possible, ability to go in with the Office of Disabilities to talk with them, like in a pre-prep kind of situation, so that you can start the ball rolling with that, because we all know how long those pieces of paperwork take. And sometimes, you might not have everything that they need to make the evaluation. And so that way you can start to kind of pre-do it, and they have to do it for themselves, but you are absolutely able to kind of advocate for them in that space.
Absolutely. And for those evaluations, if we're looking at senior year, to get an evaluation done before the start of college, because there's that 60-day timeline, you want to make sure you're doing it well before there's only 60 days left in the school year.
Okay, Jen, thank you. That was an amazing presentation. Wow, my daughter had an IEP and there's so much I forgot. There is a question in the chat, if you could take a look at that. So it's kind of long. I'll let you read it.
Let's see. Ooh. Yeah, that's a lot of bad stuff going on. Who would you talk to about getting a 504 plan? First of all, my advice with all of this that's going on, all communication should now be in writing. You want to be documenting everything, make them say it in writing, that they're not going to give you her 504 plan, that she can't attend her regular education school or her residential school, her school of residence unless she's rejecting special education. None of that makes sense. So if you're requesting a 504 plan, really what you're requesting is an evaluation to get started. And so you would, I would recommend contacting, because if your student isn't already involved in the special education system, I would involve recommending kind of the highest administrator you have contact with. If that's the principal, is that a director of student services, whoever that is, making a request for an evaluation, a special education evaluation, because you've reason to believe that your student has a need for accommodations or special services and supports so they can access their education. And then if the school denies that request, you request that them to issue that notice of recommended educational placement. And what you can do in response to that is file a due process complaint with the state and say that the school district is inappropriately refusing to evaluate the student when she is thought to be eligible for an IEP. And like we talked about before, low attendance can be related to disability. So we can't just say low attendance is we don't have to provide special education because there's low attendance, or we don't have to accommodate that. That's, we have to figure out what's driving that. Why is the student having low attendance? Is it related to their specific disability and specific individualized education needs? That should be assessed through a comprehensive evaluation. There should never be anything conditional, like you have to decline special education in order to be in your homeschool. That is ridiculous. And so definitely, I think that first step there is requesting an evaluation for a 504 plan or an IEP from the highest administrator you can.
Okay, thank you. Hopefully that answers your question, Dee Dee. Does anyone else have any comments, questions? This has been recorded, and so this was a lot of information, which was really helpful. So when you go back and watch the recording, then hopefully you'll pick up even more. I picked up a lot just by hearing this again. So
I just have one thing to say. I just like to say one thing before we go. I'm just really excited about it because I was on the Headache on the Hill, and we're doing really great work. We're asked to get our students with migraine and headache disease to be able to be covered under the 504 and receive the IEP that will give them the ability to, have their best academic lives, because we all know that they're all smart, but sometimes your body does not cooperate. So that will be something wonderful for them, because we're trying to get that done. And we've got some senators signed on the bill, and hopefully we'll be able to get that momentum to keep going forward.
That's excellent.
Yeah.
Is it looking to kind of amend the IDEA or?
No,
It's the
we're just
IDEA.
looking. No, the IDEA.
Yeah, it's the IDEA
we're just looking to get in there on the chronic pain. When they have the aphasia, when they have the mind fog and brain fog and all of those things, because those things are also things that are listed as symptoms that are covered under what is covered under those 13. So we just want to have, you know, that space to be able to get the umbrella to cover our kids with the migraine.
Yeah, so it is under the IDEA, whatever
Yeah.
statute that you referred to before, that migraine's not in there. We're trying
Right.
to get that added, right?
Absolutely. That's a great idea. That's a really important thing to have them explicitly recognized, because school districts struggle to go outside of the box sometimes and to make those individualized determinations.
Jen, this is Casey again, and I just wanted to make a statement to so many of the parents that are out there, and I just wanted to state, like I said, my son is visually impaired, to those of you that don't know, and sorry, my dog just walked right by for those of you that just saw him. I ended up having to fight the school district for him because my son was an honor roll student, and so the school was not going to provide him the accommodations that he needed because he was an honor roll student, and so they were not going to provide him with, you know, the accommodations because of that. So I ended up having to take them to court to get him the accommodations that the Commission for the Blind were coming into the school to give him. And so when I took him to court, the judge was like, this is the easiest case I've ever heard in my life. And was like, you know, you're going to get everything you need, things like that. And so what I wanted to tell everybody was, you know, like, don't be afraid. You know, if you know that you what your kids need, and don't be afraid of the school district. Like, the school district really tried to say, you know, no, your kid does not need this, and they tried to back it by saying he's an honor roll student, he does not need these accommodations. And the judge looked directly at the school and said, maybe he's a high honor roll student and you guys are preventing him from being that. And I will say, my son graduated high honors. And so I just wanted to kind of throw that out there to say, you know, don't just settle because that's what the school district says. You know, for that reason, that if you know that your kid deserves something, just truly, you know, I know all of us mama bears out there are, you know these things. So don't be fearful, and you know, just believe whatever the school says. So I just thought,
that's a good point. And I just want to add something as well, as a parent with 2 kids that had IEPs. That my daughter, the school district was no longer able to accommodate her needs in the public school. And so she had to go to private school, and the school district had to pay for that because they couldn't accommodate her without going into all the details. But that's also something to take into consideration depending on what your disability of your child is. And my other daughter had to finish high school being homeschooled because she could no longer attend school from chronic migraine, and she wasn't able to go to class at all. And so I would just say that, you know, if that happens, it's not the worst thing. I mean, there are a lot of homeschool opportunities now. And so she ended up being able to take classes at a local university and getting college credit while getting high school credit at the same time. So there are a lot of ways to get your child through school.
And something else to say about that, it sounds like you came to the school with a really great option. You're like, here's what I think is appropriate. Here's what I found. All we're asking is for you to pay for it. That makes it a lot easier for them than saying, my child isn't learning, what are you going to do about it? Which you have the right to do as a parent. You don't have to solve those problems. It's the school district's responsibility. But if you can come with solutions, with these concrete asks and solutions, it can be helpful.
Yep.
And
well, thank you. Oh, go ahead.
Oh, I was going to say, along with what Casey was saying about, you know, a student getting good grades doesn't mean they don't need services and supports. You know, something I'll see with my clients, students are getting good grades, but they're coming home and breaking down. They're white knuckling it through the day and just completely shutting down and sobbing and in pain the rest of the day. And that's that's not okay. That's, the grades isn't the only thing that matters. If they're
That's if we don't
down
see what's going on at home and the struggles that were going on at home, like watching him like struggle and like me having to sit here and read stuff to him and, and all of like, they're not seeing all of that. Right. And so that's why I was like, yeah, we'll do whatever it takes for him to pass, so that's where it all came from. So, yeah.
Well, thank you all so much. It was really nice
Thank
getting to talk
you.
to you all. And
Yeah.
enjoy
Thank
your
you so much,
Thank you so
Jen.
much. That was really
Thanks,
great. Thank you so
everyone.
much.
Thank
Thank
you.
you.